Granted, by the sounds of it, the Leader of the Opposition.
Mr President, I lead for the opposition in the second reading debate on the Drug Misuse and Trafficking Amendment Drug Exhibits Bill 2016. The opposition does not oppose the bill. The bill has two objects. The first is to amend the Drug Misuse and Trafficking Act 1985 and the Drug Misuse and Trafficking Regulation 2011 to update and streamline the system for the retention, analysis and destruction of prohibited plants, prohibited drugs, Schedule 9 substances and psychoactive substances and suspected psychoactive substances that are seized or otherwise come into possession of the New South Wales Police. The second object is to make consequential and transaction amendments and transitional amendments and provisions. The New South Wales Bar Association has advised the opposition that it has no issue with the legislation. A significant portion of the bill finds its ancestry in a performance audit by the New South Wales Auditor-General entitled, quote, Managing Drug Exhibits and Other High-Profile Goods, unquote, dated 28 February 2013. There was also some commentary by the Public Accounts Committee in its report number 17/55, dated August 2014. The Auditor-General found that police managed drug exhibits well, including the recording, storage and tracking of drug exhibits. The Auditor-General dealt with other high-profile goods as well, but that is not on point to this debate or to this bill. However, the Auditor-General did say that there could nonetheless be beneficial changes. He said, and I quote, however, there is room for improvement, mainly in regard to the effective disposal of drug exhibits and other goods, and improving efficiency by reducing the need to transport drug exhibits for testing. Nearly 7,000, or around a third of the drug exhibits recorded on the New South Wales Police's electronic tracking system, EFIMS, have been on hand for more than a year and some for over 5 years, unquote. The Auditor-General also said, and I quote further, some exhibits could pose a significant risk to the health and safety of officers, and this risk may increase over time. Police and other jurisdictions reduce the risk by documenting, analysing and destroying drug exhibits as soon as possible, with only a sample of the drug exhibited retained for court proceedings. However, in New South Wales, unlike most other jurisdictions, police must hold on to some drug exhibits until a court order is obtained for their destruction, unquote. The Auditor-General noted the development of legislative changes. He also pointed to the tying up of police resources through the transporting of drugs by police. He said, and again I quote, some New South Wales police practices are also not as efficient or cost-effective as they could be. Drug exhibits, as well as the samples taken from the exhibits for analysis, are currently moved around the state, tying up New South Wales police resources, unquote. The Auditor-General pointed out that in 2011-12, more than 15,000 of the nearly 40,000 drug exhibits collected in the state were from areas that would require overnight stops in Sydney. The residue of drug exhibit samples not used up in the analysis process need to be collected by officers and returned to police storage. An alternative is for exhibits to be weighed and samples taken locally in the regions, with samples only taken to Sydney by courier and samples being destroyed during testing. This seems to follow the procedure in other jurisdictions. The driver behind these changes is, of course, not justice, but costs. There is nothing wrong with reducing the costs of the legal system if that is capable of being done without reducing the quality of justice. The Police Commissioner's response to the Auditor-General's recommendation, dated February 2013, noted proposals for legislative change made by police. Some of these proposals seem to at last have found their way into this bill. Some of these proposals... The Auditor-General estimated the cost of transporting drug exhibits at about $1.2 million. That is equivalent, he said, to 1,000 police being away from frontline duties 2 days per annum, although he conceded that if a trip has to be made from a regional area to Sydney, then officers, as a matter of practicality, would link the trip in with other tasks. The system of destruction of drugs is complex. The police can, in some circumstances, destroy them themselves. In other cases, they currently need a court order. It is, however, a very complex regime, a point made graphically by Appendix 2 to the Auditor-General's report. Many of these considerations have found their way into this bill before the House. That includes the issue of how long police retain some evidence and the complexity of how much to destroy makes this worse. It is not the case that police are simply unable to destroy drugs without a court order. In some instances that is correct, but not in all cases. Holding onto exhibits imposes a cost in relation to secure storage. It can cause health dangers if the substance deteriorates, although the Auditor-General does assert police can destroy drugs if they are dangerous, and that certainly emerges from Appendix 2 of his report. This bill replaces Part 3 Capital A of the Drug Misuse and Trafficking Act 1985 and Part 3 of the Drug Misuse and Trafficking Regulation 2011. Division 3 of the new Part 3 Capital A deals with destruction of substances. New Section 39 Capital G provides that a qualified police officer may order the destruction of a substance where there is no likelihood of prosecution, although it must be recorded by a means such as photographing. New Section 39 Capital H provides for the destruction of prohibited plants by a qualified officer's order, providing it has been recorded and a certificate issued identifying the plant. A qualified officer in this part of the rank of superintendent or above may under 39I order the destruction of a non-plant substance where the exhibit is not less than the trafficable quantity. This applies with the bulk of the exhibit after a sample has been taken. The regulations provide for the taking and analysis of the sample and the destruction of the remaining amount. Transport will be by courier. There will be two samples, the A and B samples. Notice of proposed destruction of the bulk must be served on the defendant. The defendant can apply for a mass review application under new Section 39 Capital M. There are also provisions allowing the defendant or accused to request that the B sample be sent to an authorised independent analyst. New Section 39 Capital J provides an authorised officer with power to order destruction of a prohibited drug if it is less than the trafficable quantity after the end of proceedings. New Section 39 Capital K allows for destruction by police if an analyst certifies that it should be done in the interests of health and safety after appropriate recording has occurred. Notice must be served on the defendant or accused, although this can be overridden in the interests of health and safety. New Section 39 Capital L allows immediate destruction if it cannot reasonably be kept secure. New Section 39 Capital N provides a presumption on appeal relating to a substance. I note the Attorney-General's assurance that the presumption is rebuttable. The regulations in Division 5 create rebuttable presumptions concerning the chain of custody of a drug exhibit. There are provisions also that effectively codify the existing trial of presumptive testing of exhibits less than the trafficable quantities. Presumptive certificates can be disputed as well. The proposals in this bill will allow substances to be destroyed in some cases earlier than they presently are. They will relieve the need for some transportation of exhibits and replace some of the transport by police with transport by couriers. This legislation has taken 3 years to reach the Parliament, which I guess is pretty standard fare for this government. I acknowledge that interjection, but nevertheless the opposition supports the bill.